And thank you for joining. Today we have Gov Hutchinson, our Assistant General Counsel and Vice President of the California Association of Realtors. He's been with CAR since 1985 and manages the CAR's member legal services program in LA. He advises realtors through the hotline on all aspects of real estate law and trains and supervises on other hotline attorneys. He received his bachelor's degree from Princeton and his law degree from the University of Pennsylvania. He has written for CAR Magazine, co-authored CAR continuing education courses, and is a master instructor for the education division of CAR with certification from the DRE. He also regularly speaks to us with other affiliated trade associations, city and county bar associations, and major real estate firms. Please welcome Gov Hutchinson.
Good morning, everybody. Good to not see you in person, unfortunately. One of these days we'll be visiting in person. The only good news, I didn't have to travel today. I just walked 5 feet, so here I am. And I just want to talk to you today, as usual, to tell you about all the laws you should know about. There are a few new laws this year. There are a few new forms, and there's a couple other things going on there that I just want to tell you about. If you have questions, please just put them in the chat and I'll answer them as I go. No problem with that. Maybe we'll have time at the end if you want to unmute yourself, but I think it's easier if you just put all your questions in the chat. I'd be glad to answer them. All right. Okay. So what's going on out there? The first question people always ask me, of course, is COVID. Are there any changes? And I think the best way to say it is changes are coming, but we don't know exactly where and when and exactly what. In other words, since it's basically nothing has changed since last July. There have been no major changes. All the protocols, no traditional open houses, the PED form, all the rules that you got to do are still in effect. Nothing has changed. And unfortunately, in LA County, it's stricter than most places. LA County limits you to 2 buyers, and you still got to, wipe down the property between showings, wear the mask, the rules, all the things you've been doing since July. I think it's going to change soon. I think as things are opening up and other industries are opening up, I don't know about you, but my local movie theater opened yesterday, so that's interesting. I mean, real estate is going to open up too. We just don't know yet exactly when. We're having meetings with the governor's people, trying to convince them. As soon as it happens, you will know. We'll send an email to everybody and every realtor in California. But for now, the COVID showing protocols, no traditional open houses, the PED form, all that stuff, nothing has changed, okay? And actually, there's one new thing. Here's the new thing. This applies to your office. It actually applies to all work sites, not just an office. So let's say you're a broker, you have a work site, you have an office. You've opened your office. People are working in your office. Somebody who works in your office, one of the agents or an employee tests positive for COVID. There's a new law that says if this happens, you, who's ever in charge of the work site, real estate will usually be the broker, you have an obligation to notify everybody else who works there by the next business day in writing, telling them basically, what happened. Basically, someone, you don't have to tell them who got sick. We tell them someone in the work site got sick. This is someone who actually works in the office, and you have to disclose to everyone who might have had contact with this person in the office. What that means is during their infectious period. So let's say someone tells you on Thursday, yeah, I tested positive on Tuesday. Well, their infectious period starts 2 days before the positive test, and it goes till 10 days after the positive test. So you sort of got to figure out, okay, they got tested then. Who else was in the office at any time during that period? And if you're not sure, err on the side of caution. So anyone who was in the office during that time, you have to just send them a written notice telling them, hey, you were in the office, someone else in the office during their infectious period, and what you're doing about it, if you're did any cleaning or disinfecting about anything like that. And if it's an employee rather than an independent contractor, you sort of have to tell them what their rights are under California law, which is the right to sick leave, and they don't have to come into the office if they don't feel comfortable for a certain period of time. Anyway, we have this handout on our website. It's called California AB 685 Notification to Employees. It explains what exactly you have to put in this written notice if, God forbid, you ever have to do this. And so check that out, or call the legal hotline if you have a question. This is, once again, if someone who works in the office tests positive, your obligation, okay? Only if they actually test positive. Now, related to that, there's another rule. It's not new, it's been around for a while, but let's say I'm in the office and you invite outsiders into your office. So up until now, I was talking about someone who works there and your obligation to tell other people who work there. But what if, just have a client come to your office, and they come in, they wear the mask, blah, blah, blah. And then a couple of days later, your client who was in your office says, well, remember I was in your office a couple of days ago? Well, son of a gun, guess what? I just tested positive. Well, guess what? You now have an obligation to try to notify everybody else who came into the office within that person's infectious period. So you know what this really means? It means if you allow people to come into your office, like clients or outsiders or agents from other offices or vendors or whatever, you have to keep track of them, right? You have to keep track of people coming in. And so in other words, if someone does test positive, you have a list of people who came in, the last couple of days. So you'd be able to try to notify them. There's no particular format. What I was telling you before, there's a particular format when you have to notify people who actually work in the office. But visitors to the office, keep track of who comes in so you can notify them if somebody else who comes in also gets sick. You see what I'm saying? So that part's not new. By the way, yeah, Arturo, as I said, nothing has changed yet, but we will notify. You'll get it. We'll tell the board. We'll tell everybody. Everyone in California will get an email explaining it. Remember all these red tier and orange tier and all that stuff? But you're actually right, Edwin. That's what we are fighting to get that. In other words, logically, if movie theaters can open up and restaurants can open up, blah, 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 logically, you should be able to change the rules and showings and open houses and stuff like this. But nothing has changed yet. That's what we're pushing for. That's what we're meeting about. We have a meeting with the governor's people. So anyway, that's what we'll tell you about. Remember, the tiers, though, have nothing to do with real estate. The other thing that might change is door knocking. Right now, you're not supposed to knock on doors and initiate a face-to-face conversation. Maybe that's going to change too. But right now, you're not supposed to do that. Okay. All right. Now let me talk about new laws, because that's not really new stuff. I would say there's 3 really important new laws that everyone should know about. And then there's a few others that I'll tell you about also. But the big 3 new laws, in addition to all this COVID stuff, that you need to know about are as follows. Number 1, there is a new disclosure law. It's called the Home Fire Hardening Law. And you're probably aware of this by now, I hope. There's a new form out too called the Home Fire Hardening Disclosure and Advisory. And of course, we have a Q&A on our website called Home Fire Hardening. And we have also something on our website, just a 1-page summary if you want to see that. We have these quick guides. You just go to car.org, you type in the search quick guide, and there's a quick guide on the Home Hardening Disclosure Law. Let me tell you about it. The reason this is sort of a big deal is we haven't had a new disclosure form in California for about 15 years, believe it or not. So for the last 15 years, if some realtor asks me, what are the mandatory disclosure forms when I sell a house? My answer has been, well, you always order an NHD report, and then there's 4 other forms, NHD plus 4. And those 4 for the last many years have been the transfer disclosure statement, the seller property questionnaire, the federal lead paint disclosure, FLD, if the property is pre-78. And the last one is the 4 disclosure booklets, right? Earthquake, environmental hazard, home energy rating, and the lead paint. So NHD +4 and you're good. Well, guess what? Now it's NHD +5. There is a 5th mandatory disclosure form in addition to the NHD report, and it's called the home fire hardening disclosure. And the initials of the form are HHDA. What's different about this form compared to the other forms? This form is only required if the house you're selling is in a very high or high fire hazard zone and the house was built before 2010. I don't know if anywhere in Downey is in a fire zone. Maybe you'll never have to use this form, or maybe you don't just sell in Downey or whatever. But just in case, let me tell you, this form is only required if you're in a very high or high fire zone. I'll put it to you this way. Every one of us in California, there are 4 possibilities. Either you're not in a zone at all. I live in Culver City. I'm not in a fire zone. Or you're in a moderate fire zone, or you're in a high fire zone, or you're in a very high fire zone. This form is only required on the last 2. If you're not in a fire zone, don't have to do this form. So if I sold my house in Culver City, I wouldn't have to do it. Even if you're only in a moderate fire hazard zone, you don't have to do it. Only if you're in a high or very high. Well, how do I know if I'm in a high or a very high? Well, you simply look at your NHD report. And your NHD report, remember, lists 2 fire zones, 2 flood zones, and 2 earthquake zones. The 2 fire zones on the NHD report, one says very high zone. Boom. If that box is checked, you know you're in the zone, you got to do the form. The other fire zone on the NHD report says wildland fire area. If that box is checked, you know what that means? That means you're either in a high or a moderate fire zone. Well, the form is only required if you're in a high, not a moderate. So if I get an NHD report, neither firebox is checked, I know I don't have to do the form. If the very high fire zone is checked, I knew I do have to do the form. What if the very high one is not checked, but the wildland fire area is checked? Okay, now I know I'm either in a high or a moderate. But the form is only required in a high. Just give it to everybody. Oh, whatever, I don't care. You're in any type of fire zone, I'll give you the form. But if you only want to give them the form if you actually have to, how do I know if I'm in a moderate or a high? And the answer is you simply have to ask your NHD rep. Your NHD rep will be able to tell you if the box is checked wildland fire area, whether that means you're in a moderate or a high. Okay? Let's say I'm in a high. That means I got to get this form. The seller has to fill it out, and I got to give it to the buyer. But I only have to do this if the house is built before 2010. So if it's a newer house, you don't have to do the form, even if you're in a fire zone. So every single time you take a listing now, this applies to single family, duplex, triplex, fourplex, residential 1 to 4. I have to figure out 2 things. Am I in a fire zone, and how old is the house? If you figure out the house is older than 2010 and it's in very high or high zone, you give this form to the seller fills it out, then you give it to the buyer's agent. You know what this form says? This form says to the buyer, hey, buyer, you're in a fire zone. And since your house was built before 2010, it was built before the new fire zone building code came into effect. So in other words, you may be buying a home in a fire zone that was not built fire safe. It might still have a wood roof. It might have single pane windows rather than dual pane windows. It may have gutter covers that are combustible. So you're telling the buyer this. And then the seller has to answer the questions on the form. They have to actually tell the buyer if you have a wood roof, if you have a single pane glass windows, if you have rain gutters with that don't have non-combustible covers, etc. In other words, you're telling the buyer about these sort of dangerous features you have on the house. But you know what? You don't have to fix them. You don't have to upgrade them. You just have to tell the buyer. The buyer may say, well, I don't want to buy your house because it's got a wood roof. I want you to put on a new roof. And the seller could say, I don't want to do it. I'm not going to do it. You don't have to do it. You just have to disclose. Like I said, maybe in Downey, maybe there are no fire zones. I don't know. But this is a new law, new requirement, new form. And it's just like the TDS. If it's a probate sale, you're exempt from the TDS, you're exempt from this form. REO sale, exempt from TDS, exempt from this form. Sale by a trust, exempt unless the trustee used to be on title or lived there in the last 12 months. So if a TDS is required, this form might be required if the house is built before 2010 and it's in a fire zone, a very high or high fire zone. Okay, that's new law number one. New law number two that everybody needs to know about is Prop 19. Prop 19 takes effect a week from tomorrow, April 1st. What does it say? What does it mean? What do I need to know? All right. First of all, we have a website that's part of your car.org website. We have a special website just on Prop 19. If you want to look at it, we have Q&As. You call the legal hotline. It's pretty simple, though. Right now, for many, many years, 20 years at least, we've had something in California called Prop 60 and Prop 90. That's been around a long time. Some people don't even know about that, but under current law, Prop 60, Prop 90, if you're over 55 or severely disabled, you can take your current primary residence, sell it, and buy a new one. And take the property tax you're paying on the old one to the new one, as long as the new one is in LA County, Ventura County, Orange County, Riverside, San Bernardino, or San Diego County, and as long as the new house costs less than the old house. You have that right now. You can do that right now. So you bought your house a long time ago for $100,000 and now it's worth $600,000. So you want to sell the 600, buy another house worth 550 or something. You could transfer the property tax you're paying, the 100 based on 100,000 on your current house to the new house, 550, as long as you're over 55 or severely disabled, and it's within those counties I mentioned. Prop 19 expands that. Prop 19 says, I don't have to stay in those counties. I can move anywhere in California and take my low property tax with me. And I can even buy a more expensive house anywhere in California and still transfer my property tax from my old house to the new house with a slight. Let's say you're currently paying property tax on your house based on 200,000 valuation. Your house is now worth 800. You want to sell it, buy one worth 900. What's your property tax basis going to be on the new house? What's going to be the 200 you have plus 100, because you bought a new house that was $100,000 more than the sales price of the old house, so it would be 300,000. Remember, you can do this if you're over 55 or severely disabled, and now that's been expanded to say, if you've been a victim of a wildfire, you can do it. And guess what? You can do it 3 times. So under the current law, you can only do it once, have to stay in Southern California, and it has to be a cheaper house. Starting April 1st, it can be anywhere in California. You can do it 3 times, and the new house can cost more than the old house. Now, here's the question. Okay, so it starts April 1st. What if I've already sold a house? What if I sold my first house back in February, January, December, November? I already sold my first house, but I haven't bought my second one yet. I haven't bought the replacement property. But I buy the replacement property after April 1st. Can I still transfer the low property tax I was paying on the house I sold back in January to my replacement property whenever I buy that? And by the way, you have 2 years to do it. You sell the first one, you have 2 years to buy the new one in order to transfer the property tax. So I sold before April 1st. I buy the new one after April 1st. Or maybe I bought the new one before April 1st, but I haven't sold the old one. Can I still transfer the property tax when I do the second transaction? We think the answer is yes. CAR has sponsored legislation that if it gets passed, and we think it's going to get passed, we'll put that official, that even though you sold the first one before April 1st, you can still transfer your property tax to a more expensive house or somewhere outside of Southern California. Remember, if you're staying in Southern California and the new house costs less than the old house, you can do it right now. You could have done it anytime you want. You can still do it. Okay. Eva, yes. It doesn't matter. I mean, everybody has one primary residence, right? If you own it and live in it, that's it. It doesn't matter whether it's owned by a corporation or whatever, right? It's still your primary residence. You control it's your corporation. So yes, it does apply to you. Okay. All right. So that's Prop 19. By the way, you may have heard the bad part of Prop 19. The bad part is it pretty much took away a lot of the intergenerational exemption from property tax reassessment. You know, normally when real estate changes hands, right, it gets reassessed. You sell your house, it gets reassessed at the fair market value. Obviously, Prop 19, Prop 60, you know, is an exemption from that. You can actually change houses and keep your low property tax. Up until Prop 19, though, up until recently, if a parent transferred property to a child or a grandparent or grandchild, even though that was a transfer, that didn't trigger reassessment, as long as you were transferring your primary residence, or as long as you were transferring an additional $1 million worth of real estate. Well, now the rule is you can only avoid reassessment if you transfer primary residence. There's no extra $1 million worth of real estate you can transfer to your kid and not get reassessed. You can only transfer your primary residence, and that won't get reassessed. But that only works as if the recipient is also using it as their primary residence. But so it sounds like that's not very good. But I hate to tell you, but unfortunately, this was going to go away anyway. There was already a bill being proposed in the California legislature to eliminate the exemption from reassessment for all intergenerational transfers. So if you look at it that way, fortunately, Prop 19 at least preserved, you can still transfer your primary residence to your child or grandchild, and it will not get reassessed as long as they use it as their primary residence. What if you got 3 kids and you leave your house to all 3? Well, obviously, as their primary residence, and they can, you know, figure out how to divide it up. Okay. All right. The third important new law everyone needs to know about is dealing with rental properties. And as far as landlords are concerned, there is good news and bad news. So I'll start with the bad news, and then we'll talk about the good news. Okay. Basically, what happened was the statewide eviction moratorium was extended from February 1st to July 1st. Now, LA counties is supposed to expire at the end of this month. We'll see. But even if the LA County one expires, the state eviction moratorium has been extended. So what does that mean? Well, what it means is if you have a tenant and they're not paying rent because of COVID, you can't evict them as long as they pay 25% of the rent. Now, if they're not paying rent and it's got nothing to do with COVID, you can evict them right now. But if they can't pay their rent because they have some type of COVID hardship, they only have to pay 25% of the rent. Well, first question is, how do I know why they're not paying the rent? I mean, how do I know if they have a COVID reason or a not COVID reason? How do I know? The only way you can know is if you try to evict them. You have to send them the notice. And what notice I give them? Well, the notice to pay rent or quit, right? But you don't send them the normal 3-day notice to pay rent or quit. You have to send them the COVID pay rent or quit. So all of these COVID forms are in a library on zip form. So there's a COVID PRQ, pay rent or quit. It's a 15-day notice. So you got a tenant not paying the rent, you send them this 15-day PRQ COVID. It's actually called the PRQ TP, but it's the COVID one. So the tenant now has 15 days to respond with the declaration of COVID financial distress that comes attached to that form. If they respond in 15 days with that form, they're telling you under penalty of perjury, I swear I have a COVID hardship, that's why I'm not paying. And you have to take their word for it because they're signing under penalty of perjury. If they're lying later, they can go to jail if you want to push it. But anyway, if they send you that form in 15 days, that means all they got to do is pay you 25% of the rent. And you can't evict them. What if they don't pay even the 25%? Well, then you can evict them in July, not now. Well, what if they do pay the 25%, but they don't pay the other 75%? You can never evict them for that 75%. They owe you the money. Starting in July, you can sue them for that money. Starting in August, you can sue them for that money in small claims court, even if it's more than $10,000, but you can't evict them for not paying the COVID rent as long as they pay the 25%, okay? However, there's good news I'm gonna tell you about in a second. I might as well tell you right now, there's a way for the government to pay you that money. There's a rental assistance program that went into effect a week ago Monday on the 15th. There's a website called housingiskey.com. It's the website controlled by the HCD, Department of Housing Community Development. We have a Q&A on this called SB 91, Eviction Moratorium and State Rental Assistance. It explains all of this, and maybe I'll even send it to Jeanette later, but I mean, it's on our website, SB 91, Eviction Moratorium and Rental Assistance. And in this Q&A, there's a link to this site. If you can't remember, housingiskey.com. Anyway, you go to this website. If you're a landlord and the tenant owes you back COVID rent, you can go to this website and it'll give you an application how to apply to get the government to give you this rental assistance back. In other words, and the tenant's going to have to fill it out too, because not everyone is eligible. In other words, money has been sent by the federal government to LA County and everywhere else for landlords. Well, if the income of the tenant household that owes you rent is less than 80% of the area median income, that's defined by the county. So whatever LA County's area median income is, 80% of that is the eligible income that the tenant has to be making less than for you to get this money. And there's a link on the Q&A to that too. It shows you how to figure that out. Shows you exactly how much income, let's say it's a tenant household of 3 people, LA County median income household of 3 people, 80% of that, whatever that number is. And a lot of your tenants who aren't paying rent probably have low income because the reason they're not paying the rent is because they have a financial hardship, whatever. The point is, if your tenant is eligible, if you're eligible, then you'd apply, you'd fill out this form, and you're going to get money. Let's say the tenant owes you $20,000 of back rent, COVID rent, and they're eligible. You submit the application. You know what the government's going to say? They're going to say, okay, you qualify. The tenant owes you 20,000. We're going to give you 16,000. We're going to give you 80% of what the tenant owes you. But you have to forgive the other 20%, the other 4,000. What if the landlord says, I don't want to forgive anything. I want all the back rent my tenant owes me. Well, if that's your position, you're not going to get any of this government money. All you're going to get is 25% so the tenant can make their minimum payment. And then you can sue the tenant for all the back rent. Sometimes some people are going to say, well, I don't want to take that chance. I'll just take the 80% and forgive the 20. So I don't have to sue the tenant because I may not be able to get any money from the tenant anyway. You see what I'm saying? So once again, go to the website. If you're a landlord, the tenant owes you money, and fill out the application. Your tenant has to fill it out too, basically saying what their income is, and then put it in, and you should be getting the money. Eddie, yeah, you can evict them if they're not paying at least 25%, but you can't evict them until July. If they're paying the 25%, you can never evict them for the back 75% if they have a COVID reason. Luther, if you're asking me about a tenant that's already gone, in other words, but they did owe you back rent, yeah, you can apply for that too. Even though they're not there right now, you can still apply if they owe you back COVID rent, and they apply. Okay, so go to the website.
There was,
yeah,
sorry, there was one question on the Q&A that's
yes.
good to talk about. Edwin asked, what if the tenant does not want to fill out this form with you if they're not cooperative to fill it out?
That's a great question. You would think the tenant would want to cooperate, because by cooperating, they no longer owe the landlord the money. If they don't cooperate, the landlord can sue them forever. They can sue them, get a judgment, renew the judgment. The landlord has 4 years to sue, and then they can keep renewing the judgment. You would think a tenant would want to get out of that, but there's no particular rule. It's a good question. The law doesn't address the issue of what if the tenant won't cooperate. Maybe that needs to be tweaked or something, but right now, I think they were assuming the tenants were going to cooperate. But you're right, if they ghosted you and they just aren't around, sorry, Luther. Yeah, for the tenants that are already gone, maybe they're figuring you're never going to sue them, you're never going to find them. Who knows what they're thinking? So if you can't find them, yeah, right now, unfortunately, you do have a problem. So maybe we can try to get that fixed, but right now that's the situation. Okay. All right. Now let me get back to other things. So right now I've been talking about a tenant who doesn't pay. What about a tenant? It's not a question of paying. It's a question of they're engaging in criminal activity on the property. Can I evict them? Yes. They're damaging the property right now. Can I evict them now? Yes. They have subtenants they shouldn't have. Can I evict them now? Not in LA County. But hopefully that's going to change April 1st. But it may get extended. What if the LA County tenant has pets that they shouldn't have? Oh, but a week from now, if the LA ordinance doesn't get extended, the answer will be yes. What if there's a tenant who's not allowing me to show property? Can I evict them now? If you weren't in LA County, I'd say yes. If you're in LA County, you have to wait till April 1st, as long as that law doesn't get extended. Okay, what about a tenant? They're not doing anything wrong. I just want to evict them because I want to sell the house or something like that. Can I evict a tenant from a house? They're not doing anything wrong. I just want to evict them. Well, normally in California, you don't even need a reason if it's a single family home or a duplex, or it's newer than 15 years. But under current law, from now until July 1st to evict someone for no fault, there's only 4 possible reasons. Number one, you want to move in yourself, you or parent, grandparent, child, grandchild. Or number two, you have to do mandatory renovation to the property. In other words, there was a flood or something, you have to renovate the property to make it habitable again. You could kick out the tenant. What if I just want to rehab the property to get ready for sale? That's not good enough reason to evict the tenant. Third, you can evict the tenant if you want to take the house off of the rental market. But if you do that, you can only do that, you have to take it off the market for 2 years at least. And if you sell the house, the buyer can't put it on the rental market for 2 years. Or fortunately, there's another one, which says you can evict a tenant from a single family house if you have a buyer who's in contract to buy the house and live there. But unfortunately, you can't do any of these in LA County until the end of the month. LA County has no fault evictions right now. Hopefully, starting in a week from now, in LA County, you will be able to do these 4 no fault evictions: owner move in, mandatory rehab, taking it off the market, or selling to a buyer who's in contract to buy it and live there. If you were not in LA County, you could do that right now. If you're in LA County, you can't do that till at the earliest April 1st. Everywhere else, it's July 1st. So this is very complicated stuff. I hate to tell you, unfortunately, but we have to deal with it for the time being, okay? Now, if a tenant is still on a lease, you can't do anything till the end of the lease, right? I mean, a lease is a lease. You can't, no matter what reason you have to, I mean, if they're doing something bad, right? Or if they're not paying rent, that's different. But if it's a no fault situation, you can't touch them until the lease is over. I'm assuming they're in a month-to-month tenancy. What about when a lease is over? Some landlords think, well, the lease is over, I don't have to renew it, I can just kick them out, right? Normally, yes, not right now. Even if the lease ends, you cannot evict them unless you have one of these just cause reasons I mentioned, at least from now until the end of this month, from now until July 1st. So normally when a lease ends, say the tenant, sorry, got to leave. Not till July right now, okay? And in LA County, let's again, no fault evictions till at least April 1st. Very complicated. If your client's a landlord and they start asking you these questions, you might want to say, you need to talk to a California real estate attorney. I'm not an attorney. I don't know all these details. If you're the landlord yourself, or you're a property manager, of course, call us at the legal hotline. We'll help you. Look at the Q&A. It explains all this. It's the Tenant Relief Act and State Rental Assistance, SB 91. It's a Q&A on our website, and it'll explain everything, has links to everything, okay?
One question, Gov?
Yes, sir.
Sorry, I'm looking at the
No.
Q&A, that's why. Not the chat, the Q&A.
Oh, I see.
Somebody asked, Laura asked, what about a duplex? Can a buyer evict a tenant if they want to move in? And, which is a duplex. So I know right now with COVID, you can't do it April 1st, maybe LA County, and July 1st
Right.
for everyone else. But how about on a duplex, even in regular settings?
Yes, if we're not under COVID, and it's if you live in the duplex, just kick out the other tenant. And if you don't live in the duplex, you can use the owner move-in. So yes, you can always do that. By the way, thanks for reminding me. Now I'm looking at the Q&A. I was just looking at the Slack. So I'll look at both, no problem. By the way, back in Slack, Enrique, kicking out a tenant because you have to rehab is only if it's, like you said, major. Let's say something happened to your house and it's not habitable anymore. So you have to do major rehab to make it habitable. That's grounds to evict the tenant. If it's just a minor thing that doesn't really affect habitability, you can't kick them out until July. Now, other questions. When do I think you can do open house? I don't know. We will let you know as we're pushing hard for that. Right now, I don't know. Lucy, the 4 required disclosures. Remember, you've had these same disclosures for the last 15 years, the TDS, the SPQ, the lead paint, and the 4 disclosure booklets. My point was there's now a 5th one, which is this new home hardening disclosure. So now there's 5 mandatory if it's a very high or high fire zone and the property was built before 2010. Okay. People don't own a home, buying their first one. Yeah, the regular property tax rules apply, unfortunately. If you sell your home to your child and then bought somewhere else, it gets kind of complicated, Cynthia, but basically a transfer to your child, assuming they're living there as their residence. First of all, if you did this before the 16th of March, it didn't get reassessed. If you do it now, if you transfer to a child, the property to a child now, then they have to be using it as their primary residence. Now, if you sold your house to your child, as far as you're concerned, you're over 55 or disabled, you sell your house, doesn't matter who you sell it to, you sell your house and then you buy a new one, right? Under Prop 19, you don't get reassessed either, unless you buy a more expensive one and slightly reassessed. So yeah, theoretically, you sell your house to your child and they use it as a primary, and then you buy another house for yourself, both of you get the sort of the pre-existing rate. Right. So it's possible that both. It depends. Okay. All right. Nothing changes if it's in a living trust. It's treated just like if it was not in a living trust. Yeah. What do you do if the tenant doesn't help? What if the property's in a rent control area? Well, that only affects your ability to raise the rent. As far as evicting people, I mean, yeah, if you're in LA City, they have a very strict rent control, which takes precedence over the state. In other words, even if you can just cause under state law, if it's in LA City and it's even stricter, LA City controls. Yes, Laura, I answered your question about the duplex. Lucy, if the property is tenant occupied and currently for sale, can the tenants be evicted if they're paying rent on time so the seller can sell it? Not until April 1st. Starting April 1st, if you get a buyer and they write an offer and that's accepted saying they're going to move in, then you could do it. But I'm not sure LA is not going to extend that. So right now there's no fault evictions in LA County. In California, there's 4 possible no fault evictions, including selling the house. Hopefully by July 1st, we're going to go back to normal everywhere. We'll see. The LA County one might get extended and the California one might get extended beyond July 1st. So we don't know. Rosa, going back to Prop 19, they sold their home 22 months ago. I'm assuming you're saying they still haven't bought a replacement. So remember, after they sell the old one, they got 24 months to buy the new one. If they haven't bought the new one yet, can they do this? That's what we're trying to get clarified. We're trying to get clarified. If we think the answer is yes, but we don't know yet. Once we know, we'll send an email to everybody. Okay. So right now, the answer is possibly yes, if they haven't bought the new one yet, but they got to buy the new one and close it within 24 months of selling the old one. Okay. Complicated stuff. I understand. All right. Let me keep going. Other things, those are the big 3 laws. There's some other laws to talk about that aren't as as important as those laws, but they're still worth knowing. Number one, listen to this one. You live in a homeowner association. I live in a homeowner association in Culver City. The question is, can an HOA tell you you can't rent out your unit? There's a new law that says no, the HOA has to allow at least 25% of the people who live there to rent out their unit. Some HOAs used to say only 10%. Some HOAs say nobody can rent out their unit. HOA has to allow 25% of the people who live there to rent their unit. Now, can the HOA tell you who you can rent it to? Well, by the way, HOAs can still prohibit short-term rentals of less than 30 days. So they can still prohibit those. But they have to allow rentals of at least a month. They have to allow 25% of the people, and they have to allow you to rent out your garage or your back unit or your granny flat or something like that. They can't stop you, okay? Plus, they have to allow at least 25% of the people to rent out the whole place. Okay. Can they tell you, for example, you can't rent to families with children? No, that's fair housing violation. Can they say you can only rent to people who are family members? No, they can't do that. Can they say you can only rent to people over 55? Well, they could do that if it was a senior citizen complex. You see what I'm saying? So they can have reasonable restrictions on who you rent to, possibly, but they can't, you can't rent out to ex-criminals. They could get away with that, right? But in general, they have to let you rent it out to whoever you want to rent it out to, as long as there's already not more than 25% of the people renting it out. Okay. All right. That's an interesting new law. Here's another interesting new law. This one's probably going to surprise you. By the way, remember what I said? There's money coming for tenants. I forgot to mention, there's also money coming for property owners who can't pay their mortgage because of COVID. Let's say you or your client, you can't pay your mortgage because you have COVID financial distress. Well, right now you can go to your lender and your lender has to give you forbearance. That means if you legitimately can't pay your mortgage because of COVID, they have to allow you to delay that payment. So you don't have to make that payment till the end of the mortgage. That's called forbearance. It's a fancy word for delay. But in addition to that, this new law is going to send, this new law that just got signed by the president is going to send money to every state like California for mortgage assistance, for people who can't pay their mortgage. And the reason they can't pay is because of COVID. They may be eligible to get money from the government to make their mortgage payments. So they don't have to just delay the payments. They actually can have the money to make the payments. We don't know the details of that program because it's not going to be rolled out until May 1st. So just stay tuned for that one. We'll keep you posted, okay? But there's more money coming also. Plus, there's more money coming for landlords too. In other words, maybe the landlords who don't get the back rent compensate this time, maybe they'll get it next time. We'll see. Now, Luther, very good question. We don't know the details about whether they're going to have to prove the reason why they can't pay their mortgage. Because remember, this program is not going to come out till May. We don't know yet. Trey Howard, very good question. Is forbearance only for FHA, VA non-conventional loans? Most places that's true. In California, it's all loans. Even if it's not a federally related loan, if you have a COVID reason you can't pay your mortgage, you're entitled to the forbearance. Maybe the COVID reason is you have a tenant not paying their rent because of COVID. That means you have a COVID. So that's a good question. Okay. Anyway, I wanted to tell you that. Here's a related law, nothing to do with COVID. Let's say there's a foreclosure auction today, right? So, and by the way, some FHA foreclosures, there's a moratorium till July. VA, a lot of federally related loans, there's no foreclosures at all until July, but there's still foreclosures going on. So let's say you go to a foreclosure auction and it's on a residential property, it's on a house. You go to the auction, you have the winning bid. So you win, yay, it's your house, right? Not so fast. Used to be, of course, it's your house. Now, it's only guaranteed to be your house if you're going to live there. But if you foreclose on a house as an investor and you foreclosed on a tenant occupied house, that tenant has 45 days after the foreclosure auction to buy it back from the trustee for the same price that you paid at the auction. So a tenant has 45 days to match the winning bid. They got to close the deal in 45 days. If they can do it in 45 days, they get it, you don't get it, because they were the tenant and you were just an investor. Now, if you're going to foreclose and you're actually going to planning on living there, then it's yours. Doesn't matter about the tenant. But if you're not going to live there and there's a tenant on this property, they got 45 days to match the bid. It even goes further than that. Let's say there's no tenant. Great, I'm foreclosing on a house, it's my house, right? Well, if you're not going to live there, anybody in California who wants to live there in that house, if they sign an affidavit swearing that they're going to live there, they have 45 days to submit a bid. They have 15 days to submit a bid to the trustee that's higher than the winning bid, the one that you did. You would think, obviously, if they want the property, they're just going to go to their original auction. Why would they wait till after the first auction? Because now they got to pay more than the first auction. Whatever, maybe they didn't have the money. The point is, any potential owner occupant out there has basically a 45-day right of refusal to beat the bid of the successful bidder if the successful bidder is an investor. I guess another way to say this is, if you're foreclosing on residential property as an investor, you don't know if it's yours for 45 days after the auction. Okay? All right. Here's another new law that's good news for everybody. We've all got an increase in our homestead amount. The homestead amount is on your primary residence. You have a homestead amount, which means if somebody sues you and gets a judgment against you, they can't put a lien against your property unless the judgment is high enough to pay off all the secured loans and your homestead amount. Now, up until this year, your homestead amount that you had depended on your status. If you were single, it was 75,000. If you were the head of a household of more than 2 people, it was 100,000. If you were over 65, it was 175. So let's take me, for example. Last year, head of a household, 100,000. I have a $100,000 homestead. Plus, let's say I owed my lender 100,000 on my mortgage. If last year somebody sued me for $300,000 and got a judgment, and they won the case, they could foreclose on my house because that judgment was enough to pay me my 100, pay off my loan 100, they get the rest. This year, my homestead has gone from 100,000 to 600,000. Everybody's homestead has gone up, and your homestead has gone up. Doesn't matter whether you're single, over 65, head of a household, everyone's homestead went up the same amount. Everyone's homestead now is either the median sales price in the county where you live or 600,000, whichever is lower. I live in LA County, you live in LA County, which means since the median sales price in LA County last year was over 600, You and me, we each have a $600,000 homestead on my house, on your house, which means sued me for 699,000, they couldn't touch my house because they wouldn't have enough to pay me my 600,000 homestead plus my $100,000 mortgage or something like that. So we all have a lot more homestead protection. You don't even have to record this to get this protection. It's automatic. But I would recommend that everybody does record their declaration of homestead at the county recorder's office. By doing that, not only are you protected from someone putting a lien against your property if they get a judgment against you, but you're also protected even if you voluntarily sell this property. That lien won't attach to the proceeds as long as you buy a new one within 6 months. So it's always a good idea to record a declaration of homestead. Okay, so that's good news. Is there anything else out there you should all know about? Remember that fair housing is a big deal now. There are a lot of lawsuits going on with fair housing. You know, they're trying to get after realtors, trying to get after sellers. Obviously, you don't steer people. People say, looking for a house. You know, this is my price range. This is what I'm looking for. You show them everything in their price range. You don't look at them and say, well, I bet they're good. They'd be happier in a quiet neighborhood. So I'm going to show them in a neighborhood that doesn't have kids or whatever. You don't steer them based on who they are, unless they tell you, yeah, I'm looking for, I'm Russian. I want to live in a Russian neighborhood. Do you know of any Russian neighborhoods? Well, if you happen to know of a Russian neighborhood, you tell them. But actually, the better thing to do is, no, I don't really know. You tell me where the Russian neighborhood is, and then you give me the geographic boundary, and that's when I'll show you. Don't be the one to steer the client to particular types of property. Make them tell you, yeah, I'm looking for something south of Main Street, east of Elm Street, north of the freeway. If they tell you, they can narrow their search. Also, remember, there's this fair housing form that is now attached to the listing. It's attached to the purchase contract. It's attached to the lease forms. Make your client sign the form. By signing the form, they can't come back and say, why didn't you never told me I couldn't do that? I couldn't do that. Yeah, I did. You signed the form. And another thing that form reminds you of is California has all these protected classes. In California, when you're selling a house or renting property, you can't discriminate based on the buyer's race, religion, color of skin, country of birth, age, gender, disability, family status, that means whether they have kids, marital status, whether they're married, sexual orientation, gender identity, source of income. You can't discriminate because they're Section 8. You can't discriminate because of what they do for a living. You can't discriminate based on their immigration status, their citizenship status, their medical condition, their languages. I mean, some sellers think they can sell to whoever they want. No, it's not true. You have to make your decision on who you're selling to based on objective facts, like how much are they offering, what's their down payment, when are they going to remove their contingencies, what's their credit score, you can do all that, but based on their personal characteristics, that can't be a basis of why you decide. And related to that, you know what you see at a lot, I don't know if it happens where you guys are, but in a lot of places we see when the buyers in this competitive market, when they submit offers, they don't just submit an offer, they submit a letter with the offer. Dear seller, you have such a beautiful house. I admire how you've taken care of it. If you sell your house to us, we're going to take care of it too. We're going to take it care just as well as you did. You'll be proud that we took care of your beautiful house just like you did. Nothing wrong with that. But sometimes the letter says, yes, my husband and I and our 3 children, we love this house. It's perfect for us. We just moved here from Canada. This is exactly what we're looking for. And my husband's a dentist, and this will be a perfect house for him to open his dental practice. And then they give you a nice picture of the family. What's wrong with this? Well, now the buyer has just told the seller their marital status, their family status, where they're from, what they do for a living. And if they include the picture, that includes what they look like, their ethnic background. What the buyer shouldn't want to know. The seller shouldn't want to know, because the seller should not be making their decision based on these factors, which means as a seller, I'm better off not having that information. Because if I don't have that information, then I can't be accused of bias. No one come back to, oh, I know why you didn't sell it to me. You sell it to me because somebody, I had kids, and someone, you don't like kids. You don't like families with kids. You don't like Canadians. You don't like dentists. You see what I'm saying? So this is why it's probably a good idea to discourage these letters. I mean, if the seller wants the letter, you got to give them the letter. But part of this form, the fair housing form, paragraph 8, sort of explains to the seller why it might not be such a good idea to get these letters. And if the listing agent and the seller, the listing agent and the seller agree that we don't want these letters, then if the buyer submits a letter, you don't have to give the letter to the seller. The buyer can't say, I demand that the seller read my letter. No, seller doesn't have to read your letter if they don't want to. But if the seller wants the letter, the listing agent can't really keep it from them, right? Anyway, back to question, Edwin. What if the lender is a non-QM loan for landlords? What are we talking about here? Could you be more specific about what you're asking there? And you also have a question, Edwin. What have you heard about allowing FHA borrowers purchasing condos? I haven't heard of anything new, if that's what you're asking about. Jeanette wants this question answered. Edwin, you want to answer this? Want to unmute yourself and ask your questions if you want? Or anyway, Edwin, if you have more detail to your last question, I can try to answer it, okay? Otherwise, I think I've got most of the questions that I've seen answered. Those are the laws you need to, oh, I forgot to tell you one important thing, very important, sorry about that. So what are the new forms I have to know about? Well, I obviously told you about the new form for the home hardening. If you're selling a property that was in a high or very high fire zone and the property was built before 2010, there's a new mandatory disclosure form. And then I told you, if you're trying to evict someone, you give them a pay rent or quit, or cure breach of covenant or quit, or you try to just give them a normal 30-day notice or 60-day notice, which you can't do in LA until April 1st, LA County, you have to use the COVID form. You don't use the normal 3-day notice. You got to use the COVID 15-day notice. You don't use the normal 30, 60-day notice to terminate tenancy. You got to use the COVID form. But I forgot to mention there is one brand new form that came out related to evictions. It's called the NTRA, the NTRA 2, Notice of Tenant Relief Act 2. Why is it called the NTRA 2? Because a year ago, there was the first Notice of Tenant Relief Act. Anyway, there's this brand new form, Notice of Tenant Relief Act 2, NTRA 2. Any landlord in California, if you have a tenant, residential, who owes you back COVID rent, you have to give this form to this tenant now. If you don't give this form to this tenant now, you may have trouble evicting them in July. And you may not be able to sue them for the back rent either. So even though you're not evicting them now, even though you're not suing them now, if you're a landlord and you have a tenant behind in their behind in their rent because of COVID, give them the form, please, now, NTRA 2, to preserve your rights. So basically, I've told you about 3 new forms, right? The fair housing form, make all your clients sign it. The home hardening form, every time you sell a house in a high or very high fire zone built before 2010, that may not be you, I don't know, but do it if you have to. And then third, if you have a tenant behind in their rent because of COVID, please send them the NTRA 2 forms, okay? And those are, I think, are the most important new laws you need to know about, the big 3, and then I told you 3 other ones. The other thing, of course, I'm telling you is we're waiting to hear about a lot of changes that are going to happen soon. Number 1, we're waiting to see when you can do open houses. We're waiting to see when the showing rules change. They haven't changed yet. It's in the process. We'll keep you posted. The second thing we want to tell you about is, can you take advantage of Prop 19 if you already sold the house before April 1st? We don't know the answer yet. As soon as we know, we'll tell everybody. And the other thing we're going to find out on May 1st is if you have problems, if you're behind on your mortgage payments because of COVID, can I get some government money for that? So there's a lot of things that are coming. You just have to stay tuned. When CAR sends you an email, open it, because this is how we tell you what's going on, okay? If your board of realtors sends you something, open it, because things keep changing. Realtors, you've been very flexible the last year. Can you believe it's been a year of this? And it's going to be a few more months, but eventually we're going to get out of this and be back to normal. Wouldn't that be nice? But for now, we got to keep going. Let's see, I have a couple of questions here. What is appropriate action if you submitted an offer, it wasn't disclosed based on the purchase price being less than my offer? Luther, I'm sorry, it's the NTRA 2, not the NTRE 2. It's the NTRA 2. That's the Notice of Tenant Relief Act 2. That's the form to give tenants. What if you submit an offer? I'm not sure, Trey, exactly what you're asking. I mean, sellers have to, listing agent has to present all offers. And if you call the listing agent and ask them what happened to my offer, they have to tell you, oh yeah, I presented your offer on Tuesday at 3 o'clock, or I'm going to present the offer at Friday at 4 o'clock. They have to do that. But maybe what you're saying is the seller didn't accept the offer. Do they have to tell you why the seller didn't accept the offer? And the answer is no. I mean, what if a seller says, I want a conventional offer rather than an FHA offer? They have the right to do that. That's not discrimination. Or I want a cash offer rather than a financing offer. Can I discriminate against people who aren't paying cash? Yeah, they can do that. So maybe that's what you're getting at there. A couple of important things though. If you ask the listing agent what happened to my offer, they have to tell you. Either haven't presented it yet, tell them exactly when it was presented and the seller didn't want it. Ideally, the seller would initial that rejection on the last page of the offer and send that back, but sellers aren't required by law to do that. But listing agent is required to tell the buyer's agent what happened to their offer. But if it's a question of maybe the seller said to their agent, only show me offers over 500. Only show me offers that are conventional financing. Only show me offers over 600 conventional financing. I mean, that's not discrimination. They're not discriminating on what type of person the buyer is. They're discriminating based on the offer itself. So that's a good, now Roselia, that's a good question. They tell you they submitted it, but they lied. They tell you, oh yeah, I presented your offer at 3 o'clock on Thursday. And they didn't. You suspect them of lying. You know what you can do? You know what your buyer can do? Your buyer can call the seller up directly and say, was my offer presented at Thursday at 3 o'clock? Buyer has the absolute right to contact the seller and tell them. So the listing agent probably shouldn't be doing that because they can get caught. They can get
And
caught because you have the right, and you even, and once escrow closes, you can contact the seller. So it's a bad idea for listing agent. Okay, good question.
Gov, there was a good question on the Q&A, and Edwin kind of clarified his question about
Oh,
the
okay.
FHA. So in other words, do you think it'll come around that they will allow FHA offers or, loans to go through on a condo where right now, there's many complexes that are not FHA approved? And do you think that may come about since we're having a inventory crisis? So
In other words, I think what you're asking is might it be that all condos are automatically FHA approved or something like that? I think that is a strong possibility. I think that might actually happen, but not yet. And we're pushing for that. You're right, because the issue is inventory. I mean, that's a one way to open up inventory, and we are pushing for that because you're exactly right. That is that's a way to make more properties available, because people might have FHA financing and that's the only way they can finance it. So yes, so we are definitely pushing for that. Carlos, what if it's a judgment lien that's already recorded? Yes, if they haven't actually done the foreclosure yet, they can't do the foreclosure. So in other words, even if the lien was put on the property before the law changed on January 1st, you still are protected from foreclosure based on the new amount. Okay, so that's a good question. Marlene, what if the listing agent says no more showings? Well, that's up to the seller, right? I mean, some sellers get tired. I'm sick of showings, no more showings. As long as they're not discriminating based on what type of buyers they are, as long as they're just saying we've stopped doing showings, no more. It's got nothing to do with who the buyer is. We just don't want to do it anymore. I mean, that's a seller decision. Ultimately, the sellers can decide, like, what if you get 10 offers and the seller only wants to counter 3 of them? Is the seller required to counter all 10 if they require any of them? No. But they just can't be countering the ones from certain types of people, right? That's a violation. But if they just say after 3, I'm done, I'm not going to counter anymore, I don't care. As long as that's not based on any type of discrimination, they're allowed to do that. By the way, if you ask a seller, if you ask the listing agent, do you have any other offers? Do they have to tell you? No. They can't lie to you, but they can say, my seller doesn't want me to answer that question. But if you do answer the question, if they ask you, do you have any other offers? If you're going to answer it, you have to give a complete answer. You have to say yes. You can't just say, yes, I got other offers. You have to say, yes, I have 8 other offers, and 2 of them are from my buyers. So if you're going to answer the question at all, you have to answer it completely. But you don't have to answer the question at all if the seller doesn't want you to. So what if the buyer says, how much are your other offers? Do you have to tell them that? No. Can you tell them if you want to? Yes. Unless the buyer submitted a confidentiality form before they submitted their offer, which they never do, you can tell somebody else how much the offer is you've already got. You don't have to tell them, but you can if you want to. Okay. Marlene, you're right. You want that in writing. I mean, okay, so you say, they say no more showing. You say why? And they say the seller doesn't want any more showings. You say, I don't believe you. I want that in writing, signed by your seller. Well, yeah, you don't really have to do that. You can always catch them later lying, right? And as I said before, during the escrow, even before it closes, the buyers can contact the seller directly. And after escrow closes, you can contact the other client. Listing agent's gonna have a heart attack when you do this. But after the deal is closed, you can contact them to see if, the offer was presented. Because you're not interfering with a transaction and you're not contacting someone else's client, because after the deal closes, they're not their client anymore. They're not anybody's client. Anyway, I'm not saying you should do this. It's going to cause bad blood, but if you think they're really lying about it, you don't care whether it's going to cause bad blood, you're going to contact them. And the buyer can always do that, right? The buyer can always contact the seller to see, why didn't you respond to my offer? Did you get my offer? Why did you sell it for less money than I offered? Buyers can always do that. Okay. So sometimes you got to do what you got to do. All right. Very good questions you're asking. We're hearing this all the time. And, and that's about it. Anyway, I don't see any more questions. Oh, okay. Edwin. Yeah, right. The highest offer or amount. By the way, you're seeing this, you're seeing people write offers. We're seeing list sellers say, we got too many offers. We're not going to counter them. We just want everyone to resubmit their highest and best offer. There's nothing wrong with that. That's probably a good thing to do. Rather than trying to counter 10 different offers, you can always ask people to resubmit. You're telling them specifically, we're not responding to your offer. We're asking you to resubmit. So they're telling you that was a sell. I'm assuming that's a seller decision, right? The seller can do that. As long as they don't discriminate. But you can discriminate. You know who you're allowed to discriminate against? Investors. Some sellers say, I want to sell my house to someone who's going to live here. Only show me offers from people who actually want to live there. That's discrimination against investors, but that's legal discrimination. See what I'm saying? Very complicated. If you have questions, please call us up. It's a crazy world we're living in right now in real estate. Not only these crazy COVID stuff, but these crazy multiple offers you got to deal with. Gets very complicated. But that's about it I can talk to you about. Have you seen any non-contingent offers? That's a risky thing to do. Some buyers think the only way I'm going to get my offer accepted if I have no contingencies. That means you find out something you don't like about the house, too bad. However, even if you make a non-contingent offer, you still have 5 days to cancel after receiving the disclosures, including the new home hardening disclosure. Okay. All right. Michael, I think I'm done.
Yeah, great. Well, thank you for everything and for the information.
My pleasure.
Okay. Thank you
We'll see
everyone
you
for
next time,
joining as
guys.
well. Thank you, Gov.
Bye,
Thank
everybody.
you, Gov.
Welcome. See you, Jeanette.
Bye.
Bye-bye.
Bye.
Thanks, everyone. Thank you, Michael.
Uh-huh.